All right, let's go ahead and get started. So welcome back. This is Contracts Class 6. We are going to go through our usual setup. I don't have any administrivia, so unless you have any questions about the form and what we do in the class, we'll pass through that. Then I'll give us a brief, go ahead, Leland, yeah.
The email that went out last week for September 23rd or
yes.
Class that's rescheduled, it said Tuesday.
I know, Jane, I called her within 30 seconds of her sending it, and she's like, oh, no, it's not, it's the Wednesday class.
It's the Wednesday?
I'm leaving on Tuesday because I've got to fly to Paris, but it's for the blockchain conference, but it's the Wednesday class that's replaced. Thank you for asking, appreciate it. Cool, anything else? I'm glad we had this moment. Yeah, go for it.
The tests, previous year's tests that are on file.
Yes. Where is that file? So we've had this back and forth. Go ahead.
I sent you the link.
Yeah, so that link is there. The library also knows where they are. And you can also ask my admin, Jane McDonald, for it. If you email me, I'll email you the link. Bailey went and checked right after that class. They said they had no idea where they are. I went and screamed at a few people. They now know where they are. They are on the law library past exams website, which I think was crawled by Google, even though it's largely internal. And so if you just Google past exams or prior exams, Washington and Lee law, you'll be able to find them for everybody, and mine are in there. We checked them. They're all there. Nick.
Oh, no, I was checking to make sure it's more than just the last one. Because when I first looked, I only saw the last one. But
They're out of order. It is the website was clearly, state of the art in 1990.
yeah, they're all here now. Okay, I just checked it.
Yep, cool.
And I have the link.
Any other administrivia? Cool, well, that's why we do this. Then let's move into where we are with contract formation, offer and acceptance. We've done consideration at length. You know what it is now. Offer is an offer to form a contract made in terms that make it clear to the recipient of the offer that it is an invitation to enter into a contract. It is not just merely a negotiation, right? But it is an actual offer to enter into a contract. And an acceptance is the same thing. It is a sign, symbol, or other action that is the acceptance of the offer. The only trick is that at common law, the offeror is the one in control of this rodeo. We will notice that that rule changes when we get to the UCC, but the offeror is supposedly the controller of the offer, and therefore the offeror can limit the ways in which the acceptor may accept the contract. We also learned then something very important from the cases, including Ford Motor, which was that who is the offeror and who is acceptor, first of all, have a lot of impact on the terms of the contract, right? If I make you an offer and you accept, well, the terms are those terms that I offered. If I make you an offer and you reject and counteroffer, and then I accept, the terms are the terms of your counteroffer. And so on down the road. That is, as these disputes come out in court, one of the major ways that we have of manipulating or making the best case for our client, whatever you want to call it, the outcome of the decision is by changing who is offeror and acceptor. Another way of putting it is never, ever, ever accept opposing counsel's description as to who is the offeror and who is the acceptor. Immediately turn around and be like, okay, yeah, but what if it wasn't, right? This is my oldest daughter sometimes speaks on behalf of our puppy, right? And so we would say things like, this is not for Jasper, right? And then MK, my oldest, would pipe up and say, yes, but what if it was for Jasper? Because you can just see that in his expression. What if the bacon was for Jasper? Similarly, right? What if the other party was the offeror and the acceptor? Would that change the terms of the contract? And the answer is often yes. It's one of your first most powerful moves as a contracts attorney is to change the character. We know what an offeror is. We know what an acceptor is. Just remember, don't believe anybody as to who those people happen to be in a given case. Don't get locked to that. A is the offeror, B is the acceptor. There's one exception, right? If somebody starts using verbs on you on the bar exam, right? Like A offers and B accepts. You're like, okay, that's not what they're asking me about. We are talking about something else, right? Like take their verbs seriously if they do it. But if they don't, then you're off to the races. All right, that's what we mostly spent our time doing. We then learned a few things about offer and acceptance. The first thing we learned about offer and acceptance is don't get too focused on how the offer comes across and trying to create this click, this single moment in time. Because the single moment in time creates a real problem. The law needs that click because before offer and acceptance match up and you get that click, there's no law binding the parties. Either party can just walk away. There's no rule here. After that click, the parties have entered into binding legal relationships. And so you can see why the court is so focused on getting that click no matter what, on determining when it happened. But also understand, it is a legal fiction. That click isn't really a thing. What happened was somebody started to negotiate with somebody else, and it went on and on and on, and maybe they even started doing business with each other, and it went on, and they started preparation, but then preparation merged into actual performance, and they go on and on and on, and at some point you're saying to yourself, ooh, I think that I have to pick this moment here rather than here to get the case I want. But look, at some point, we mentioned it yesterday with the Best Buy, last time with the Best Buy analogy, somebody can get all the way home with a piece of electronic equipment and not have seen the contract yet, right? So don't think just because the parties have actually begun doing the thing that there must have necessarily been a contract first. That moment of contractual formation is critical to courts, but it's kind of the court's own problem. The court is the one that needs it. It doesn't really correspond to reality. What that means is you will confuse yourself if you insist on thinking that there was a specific moment where the contract kind of came into existence, and before that there was no contract, and after that there was a contract. If you're looking at the facts of the case, go look at them and say, okay, yeah, I could make a case for the moment being here, and I could make a case for the moment being here, and I could make a case for the moment being here, and I could make a case for the moment being here, and what's that gonna do each time? It's the same move that we're pulling with offer and acceptance, but we're now just pulling it with that click. When does that click happen, and when do we move it? The court's demand for a click is not anything that's reflected in reality. It is a legal demand that the court has to make in order to understand, was there a contract or not? But you, as lawyers, should unpack that and be willing to call, in forming your arguments, you should be willing to call almost any part of this the moment, if it fits your argument. Okay? Cool. Nate, yep.
Clarification on that. So you're saying like the court is looking for one click, but as lawyers, we're trying to persuade the court that our click is the click.
Yep, that your click is the click, because your click is going to set the terms of the contract quite often, especially given, now let's step out of contract law and back into human reality, especially given the reality of contract negotiation, which is that the parties over a period of time exchange a series of documents and discussions that then they may start performing on. That's what actually happens in real space, right? It's not handed to you from on high. There was no contract before this moment. There is a contract after that moment. So you're trying to time that in order. It's one of the strongest arguments you can make. It is not a fact given to you. This is one of my big beefs with the bar exam. The bar exam thinks that there are legal facts. They think that somebody is the offeror and somebody is the acceptor. Pass the bar, that's fine. But then I want you to be actual successful lawyers. And so to understand that, as with most other legal facts, the moment of the click is really a lever, and your goal is to pull it from one end of the case to the other as hard as you can and set it to the setting that you need in order to win the case. That's what's going on. And so if you have a deep confusion, I don't know when this contract was actually formed. Like you read a case, you're like, yeah, like the court said the contract was formed on Wednesday, but hell, I could have made the case. I think I could have made the case that it was formed like 2 weeks before that. Heck, I could probably also make the case that it hadn't even been formed because they left a lot open. They hadn't even been formed until like 3 months later, until they solved those issues. Good. That means you're now thinking like a lawyer thinks, and you're thinking about this as a lever that you can move, not a series of facts that you are constrained to follow. You with me? Awesome. Any questions about what we've been doing on offer and acceptance? We basically defined them last time. We learned a few things about them. In Ardente versus Haran, we learned a grudging acceptance is still an acceptance, right? If you say, yes, darn you, that's still a yes. If you say yes, and though, you have not said yes. So make sure that if you are saying yes, but I'd like to also confirm the following, put those in two separate writings. Say yes, and then send a separate writing so that you don't get caught up in this confusion about rejection and counteroffer. So we learned the rejection and counteroffer rule. As a part of that, we learned the mirror image rule, which is that at common law, the offer and acceptance must mirror each other. That usually, in 99.999% of cases, does not mean that the offeror and the acceptor have the same legal language, identical down to the period that they've sent to each other. And more often, what it means is that the parties go back and forth, and they say yes, and 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 yes, right? It's like a game of hot potato, right? Like the person who says yes is the one that's like holding the bomb at the end. And they're the ones that are accepting the terms that were sent to them.
So is there a particular advantage or disadvantage to being the offerer or the acceptor?
Yes, there is. There is, and that is, you should now understand that that is liquid nonsense, that it shouldn't be that way. If we have contracts as bargain for exchange, we will see that this idea that the offeror generally tends to win all of the cases starts to really rankle. And we'll see how the Uniform Commercial Code tries to abolish that and just say, look, there are just two people entering into a contract. What do I care if one person's the buyer and one person's the seller? The buyer can make an offer and the seller accepts, or the seller could make an offer and the buyer accepts. This idea, right, of what's called the last shot rule, that is a logical corollary to the mirror image rule. The logical corollary to the mirror image rule is the last shot rule. The last shot rule says, whoever said yes and last before the other person says yes wins. We will see how that doesn't work at all in the industry out there. And so they tried to abolish the last shot rule. We will see how they did that in this 2207, UCC 2207, which will be the most difficult statutory provision we will look at in this entire class, and I will make it easy for you. There will be flowcharts. It's gonna be fine. But, and I'll literally tell you, look for this word, draw an arrow, do this if this, do that if not. Like, it's gonna be real straightforward. And it, by the way, is really important to know. I had a former student, now contracts attorney, government contracts attorney, call me last week and say, what we studied in class wasn't really true, was it? And I said, and I walked her through it, and she's like, okay, cool, we're gonna win. Like, it turns out to be true. But the whole point that they were making when they did 2207, which I'm reaching forward, we'll see it in a little bit, the whole reason that they did it was because this idea of the last shot rule is nonsense. If offer and acceptance are largely just a matter of lawyers dueling characterizations, then you can see how it's pretty much nonsense to assign it to one person or the other. Why don't we just say, hey, the contract consists out of what the two of you agreed on, and anything that y'all disagreed on isn't part of the contract, which is what they did to the mirror image rule in the UCC. They said, it doesn't matter if the offer and acceptance don't mirror each other, we just make a contract about what you did agree on, and we leave out everything that you didn't agree on. That's another way of doing it. They did that, it created its own problem. And then if you track the industry changes from cozy core, that's what we had up through the Second World War, to the industrial economy, that's the UCC. So cozy core is our black letter law of contract. UCC is our laws of trains and factories. And now we're getting into then the IP economy of the early 2000s, and then now the data economy, where we are the product, right, that is being sold. Data about us is the product that's being sold. And you see in the shift to that economy, some desperation to move away from the UCC rule and get back to the person who delivers the contract terms always wins rule, which is essentially what you see in Amazon, bolstered by a bunch of other things. But your experience in your daily life of I don't get to negotiate contracts at all. Like, I don't get to add a term to my contracts with Amazon. That's not a thing. If I buy a video game, I don't get to add a term to that. That's not right. That modern experience then is a return to the old rule of, it turns out if a computer offers a human a contract, the computer always wins because the computer is deemed to be the offeror and the human who accepts is the victim, the acceptor. All right, further questions on anything that we have done in this class up to date? Yeah, go for it.
Yeah, is there a difference between a free option and an illusory contract?
Illusory contracts is an old school, cozy core way of describing something that is almost always a free option, right? That is, if I say to you, let's do, and I warned you about this, right? I warned you that we need to take the intuition of illusory contracts, but we need to apply them not by saying every contract that we've ever run into is illusory, because that can really start to spread fast. A lot of contracts do have hidden free options, right? We'll see one today, right? Where Empro, frickin' Easterbrook, uses somebody's own option to get out of a contract as a way of letting them out of the contract. Like, that's just such a nonsense move to do. He made it illusory to give one party the ability to get out. And we got to talk about why he did it. I think he was probably actually right in that case, but which is for me to say about Easterbrook. Whew, that's a moment. But it is easy to see that just like, right, all nickels are money, but not all money is nickels. Pretty much all illusory contracts do create a free option, but not all free options are clearly illusory contracts. The way that an illusory contract, that is, it looks like a contractual obligation, but it's not, that's the illusion, works as a free option is this. It looks like we are both bound, something for something, but we're not. You're bound, but I'm not. That's the option. You're bound, but I'm not. And anytime you see somebody where you're bound and I'm not, we'll see this in AA builders today, that creates this problem, and we need to worry about whether or not we're letting somebody get away with murder. We have to figure out if there's another policy reason or industry reason or something else, as we see in AA builders. There's some other reason why we're going to let people fly with that option, which we do all the time. In the entire industry of used car sales would collapse without the free option of the 2205 firm offer rule from the Uniform Commercial Code, right? So sometimes we do that. AA builders makes the argument. Are they right? We will ask. But AA builders makes the argument that the entire building industry would collapse if we didn't allow an option at the hands of the general contractor and damaging the subcontractor. That's their claim. But until we find that, yeah, the idea that I'm bound and you're not, that's where an option is, right? Cool. That's why it's called an option. Any other questions? That's a great one. Yeah, Fletcher.
One of the cases talk about the parole evidence rule.
Oh, huh? Yep.
Have we gone over that yet?
Nope.
Okay.
That will be our primary long dark night of the soul about formalization. If I don't say it then, I'm saying it now. Every time we talk about the parole evidence rule, we are talking about formalization, and specifically in the following way. The parole evidence rule we have not studied yet. I'm just telling you what it does because it relates to what we have just talked about. What it does is it excludes evidence of the parties' prior negotiations if there is a final signed and sealed agreement. What that means is that all of these arguments that the contract could have been formed here, 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 have a real possible block. It's true. It could have been formed here. It could have been formed here. It could have been formed here. But all of the ones that are formed, could be formed, could be formed, could be formed before the parties sign the damn thing runs the real risk that the court will say, I am going to exclude all evidence of what happened before then because this agreement says that it is the final written and complete agreement of the parties. There are a bunch of technicalities that go with that rule. We have not gone over the entire rule now. Parole evidence does not mean you are out on parole from jail. It is parole from French, meaning oral evidence, but it does not just apply to oral evidence. It applies to all evidence of negotiation between the parties prior to a document being signed, which by its terms states that it is the sole and integrated agreement between the parties. That's what the parole evidence rule is. All right? We haven't gone over it yet. We absolutely will. Anything else that y'all want to know before we pile into Shoney's? Seeing a dangerous pen, but I think you're safe. That's a problem too. Like Richard Epstein in my contracts class nailed me all the time because I had this thing where I would spin a pen, and he's just like, "What?" Anyway, I was playing Quake in contracts, so I don't know. Against Josh Urquhart. I don't think Professor Epstein ever caught me. All right. No further questions? Cool. Then let's get into Mid-South Packers. And Dasha, if you wouldn't mind setting it up for me, please.
Yeah, sure. So in April of 1982, Mid-South and Shoney's began negotiations for the sale of many pork products between the two companies. Mid-South submitted a letter styled as a proposal, which outlined the price and terms, and it did all that without having a set duration of the times between them. And Mid-South claimed in the proposal that it would inform Shoney's within a 45-day period when the price would increase. This contract or proposal went on for a couple of months, and then on August 12th, 1982, Mid-South informed Shoney's that it would have a 10-cent per pound price increase. This was agreed upon, but there was never a written agreement or anything stating that Shoney's would accept this. Then Shoney's just continued on with regular business, believing that it was paying the old price, but instead Mid-South was invoicing it for the new price. And then when Shoney's found this out, they offset $26,000 and $208. Sorry, my brain is gone. But yeah, around $26,000 and claimed that it was overcharging. Then Mid-South filed a suit for recovery of the offset amount, and then Shoney's later admitted that it did owe $8,000 of those dollars because it was past the 45-day period, but the other amount, it still claimed that it was not part of the contract.
Okay. And so just, yes, that's a great sort of setup for it. I do have some follow-up questions. I do want to catch quick because I saw a hand go up in the middle. Chris, was there a? Cool. Oh, I'm clearly hallucinating this. All right, I got to watch my tendency to like spot hands. Go. All right, now you're messing with me.
I think an important fact is that they did know that there was a price increase.
Yep.
And, it was like their secret evil plan.
Yep.
To pay that price increase.
Which was the very first question that I was about to ask, which is, wait a minute. They didn't know about the price increase?
They knew, but they claimed that they didn't.
Uh-huh. And that's called lying. And the court fucking knows it. Pardon my, damn, I'm on camera. And the court knows it, right? And so I'm not even touching the doctrine. Who loses this case?
Shoney's.
Yeah. Now, why does Shoney's lose the case? The error in the sales. I'm not talking anything about the law at all. Who loses this case? Yeah, and why?
Because it claimed that this was a requirements contract for a long.
That's law. I'm with you. You're absolutely 100% correct. And that's going to be my next question. We're going to do what were the two characterizations of the thing? Why did they lose?
Because they flipped a coin, and then they hoped that the law would be on their side.
Right. That is, they were the ones, they accepted the price increase, right? They accepted it, and then they wanted to do business based on that price increase. They knew damn well the price they were being charged. They just wanted to get the stuff and then charge back a lower price later on. All right? So the reason that Shoney's lost the case is because they're lying assholes. Now, doctrine to help the court get there. This is one of the best examples of what I mean when I say that you need two things. You need the motivation to get the court there, and then you need the black letter law that drives them there, right? Okay, cool. Now you're absolutely right. What are the two characterizations? We know who wins. We haven't even touched the law yet because we know that if there's a competent attorney that gives the court a way of doing this, the court's gonna do it, all right? So, and if you want to take notes on it, it's just the reason that Shoney's lost the case is because they were engaged in secret double bookkeeping. It's never a good look. They knew what was going on. If they had not wanted that price, if they had wanted to resist that price, what should they have done, Dasha?
They should have went into an actual contract and stated it.
They should have gone into the actual contract and stated it. They should have said, no, we reject your 10-point price increase. Do not send us more stuff until we agree upon a price. And if they'd have done that, I know the reason that I'm raising all this is because we're about to have all these black letter law rules, and it'll occur to you, wait a minute, but what would have happened if they'd have done that? And the answer is they would have won the case. And so we have to be very wary about taking these legal arguments that help them get there as absolute gospel, because they're not. All we have to do is change that one fact. I know, I've seen me do it on my exam. All we have to do is change that one fact and have them upfront negotiate for the price change. If Shoney's had said, nope, we do not accept that 10-point increase, we therefore aren't gonna accept shipments from you until we get this hammered out. There's no way they lose this case. So we have to figure out then what the Sam hell is going on in the court's interpretation of the black letter law, given that it's motivated to catch the lying assholes, right? All right, cool. Right.
Worse yet, they even got them down to a 7% increase,
and then we're just like, no, we're still gonna get, right, we're still gonna engage in double bookkeeping. The reason I raised this is because, what do y'all think? This is the last time we're going to see this fact pattern? No. I mean, all the time. And when you are working for a company, the C-suite always is going to think that it's cute, funny, and no one's ever thought of it before to defraud their business partners. And it's not going to work. And one of your major jobs as a lawyer is to say, no, a little light fraud is not okay. You're going to lose when this comes out. It can't happen. Don't do it. If you don't like the price increase, say something up front. All right, cool. Now that we've gotten the wind out of the way, let's go to the rudder. There are two characterizations. First of all, even before we get to the black letter law characterizations in the case, I don't know how to ask this. In the course of here's the way to ask it. What kind of law are we under?
Currently we're under UCC.
We are under UCC. Why are we under? Well done. Why are we under UCC?
Because this is technically a service, so it can't.
Service? Can you move my teaching? No, that's a service. I am currently performing a service. I hope I make it worth it. Why is this not a service? Because, by the way, can you see why it would look like a service? So I keep getting grouchy emails from my spouse, and I'd fully deserve it, because there are boxes that show up and because our driveway is washed out. I already told you about that. And the UPS drivers won't drive up to our house, which I think is a benefit, not a flaw. But the problem is they leave these Blue Apron boxes at the bottom of the hill. Now, Blue Apron is one of these things where you get, it's basically a subscription for a couple of easy to cook meals a week, right? Which we need because we're all working way too much. And if I leave them down at the bottom of the hill, then they melt, and yeah, that's ugly. But here's the thing. Would that look, I just said it's a subscription for meals. And it is. Is that contract governed by the UCC, or is that governed by a services agreement? It's UCC. Somebody tell me why. It's movable goods. Even though, and to be clear, could you describe it as a service? Yeah. And what law would govern if you successfully described it as a service? Common law. And yet another lever, folks, right? Let's try this. Anybody want to take a crack at this? Extra participation if you get anywhere close. Would anyone like to try to write an exam question that makes it profoundly ambiguous as to whether or not it's a subscription for food or movable goods? Yeah, go for it.
That Mid-South just delivers the food.
For example, right, if it's just the delivery service, which it often is, if that was all they were contracted for, let's get off of Mid-South and let's just make something as ambiguous as we possibly can, because you're a jerk, which is the inner soul of a law professor.
What about like an internet order hibachi chef?
Now we're talking.
Grill and the food, he comes over, and then there's product, there's food.
Right.
That I consume, so that's a good end of service at the same time.
That's fantastic, right? So like home cooking lessons, right? Like, Liam, you were going to say? I'm going to get a bunch of these.
Say the chef, yeah, private chef.
Okay, you're going to say a private chef who comes in. Service. The thing is, private chef is service or UCC. Hiring an actual private chef. Let's imagine we're rich beyond the dreams of avarice. Yeah, that one's a service. So we have to watch that we don't, if you're in writing your exam questions, and here I am definitely saying the quiet part out loud. You have to be very careful. It's really hard to hit that exact gray area. Why am I telling you this? Because I do it a lot, because everybody does it a lot. Because what it means is that I'm showing you you can use this lever, because you can move it over here and get UCC treatment, or you can move it over there and get common law treatment. I saw a couple of other hands. Give me a couple of other examples of this one. Yep.
Traveling something, like
A traveling circus? What's a traveling circus? Service or goods? I mean, elephants are movable, but still there's the goods element, but no, probably service. Anybody else want to try to put it right down the middle? Yeah.
I was going to say, how would something like Netflix apply? Because it used to be that they would mail out a DVD.
Yeah.
Now you're
I can't ask that. That's exactly the question that I used to ask. I can't ask it anymore because nobody's like ever heard of a CD-ROM drive or a DVD, right? But it used to. So what the example I used to use was you had a bunch of old home movies, and so you went to a person to have them burned onto the CDs. See how that one's right down the middle? Yeah, because somebody make the case for me that this is obviously, Your Honor, Uniform Commercial Code. Yeah.
you're paying for the CD with your home.
Because I'm giving you money and you're giving me CDs. And last time I checked, you could move CDs. Now, unfortunately, in the last life of my CDs, we were largely throwing them in the air and shooting them with shotguns. But you can see how they are movable, right? And now make the ironclad case, and I'm going to ask you to do it because this is the whole point that Carl Llewellyn was making about lawyers being able to hold two exact opposite thoughts in their head at the same time. Make the case, this is obviously a service, Your Honor, and there's no question it can't possibly be just the discs.
Because what you'd be paying me to do would be to transfer this stuff over.
Yeah, because you're paying me to if you wanted a bunch of blank CDs, at that point in time, I know this is ancient history, you would go to Best Buy and get a stack of blank CDs. We still have stacks of them. Like I still find them in the backs of our closet sometimes. This is where we would just burn family photos on them. All right. Yeah. Annika.
What does like Uber Eats or Favor fall under?
Good question. What's Uber Eats? Service for whom? This is why this is a key question. So let's say that we're asking, the dispute is that the goods are not, for example, the food is terrible and you're suing somebody on that. You're going to use, I want to ask you which regime is better. I just want to know, if you're talking to the restaurant, do you get service or goods? Which way do you want to go with that one? Or let's try the driver. The driver, service or goods? Yeah, clearly a service there. The restaurant, service or goods? Yeah, I like that look, right? That's where I'm going with all this. That look of, see, that's the look on the judge's face as you're about to win by pulling that lever one direction or the other. That's what's going on there, right? What do you think? Arguably, right? Because we can pull it that one direction, because if I go into McAdoo's or whatever the hell they call it there, on Main Street and I order a hamburger, is that a goods or a service transaction? Well, that's the point that I'm about to make. But is that a goods or a service transaction? That's a service. Somebody said it. It's a service. Yeah, it's a service. Why is it a service? Because they make the food. Well, our hamburger is mobile. Now that I have messed with you, what I'm going to do is give you the rule, since it seems appropriate, and then you'll notice that having given you the rule, I have not given you the way of telling the answer to these cases. I have given you the way to convince a judge that any of these cases works out the way you want it to. Here's the rule. The majority rule is called the predominant purpose test. The predominant purpose test says when a transaction is subject to a mixture of services and goods, the question you should be asking yourself is, did you mostly want the goods or did you mostly want the services? Now that's the rule. I swear to God, you can put that in your pleadings. But anybody who just listened to what I just said was like, wait a minute, it has to do with what the party mostly wanted. David's response is basically right. It's like, okay, that's what's called a content-free rule, right? Like, it's just a tool handed to lawyers to beat people with, right? Joanna, yeah.
Can you please repeat that?
Yeah, the predominant purpose rule says, When a transaction is characterized by a mixture of goods and services, which all of them are. Y'all, characterize the sale of this pen as a services transaction. Do it. Delivering the pen might be one. Give me more.
I had to put ink into a.
Somebody had to fill the pen. For those of you who've ever been to Finland, the building of the pen, the design of the pen. Have you been to Scandinavia? These people are completely obsessed with design, right? So the design of the pen. By the way, what question do I ask? And I'm showing my cards right now. I will forget that I told you. What question will I ask? I ask it almost every year, and it goes straight down the middle on this design the pen versus the object itself.
Is it the card decal one at the detailing place?
Card decal's pretty useful, although you pretty clearly want the service of painting it, right? No, it's 3D printing, y'all. See how I can mess with you all day long on the design of the object versus the files to design the object versus the printing it out itself? Which one did you want? And I just have people custom print something. Custom printing is a nightmare for the predominant purpose rule. What do you do when I give you a nightmare question? I know, I've seen me do it. When I pitch that 3D printing question right across the plate, you will lose if you get caught up in the idea of, which one is it? Which one is it? Which one is it? The answer is, I can make this anything I want. And then you just tell me how and it's full points. See how that works? Just catch me doing it. Be like, cool, this one's one straight across the plate, right down the middle. I can make it whatever I want. Yep, Bailey.
So, for this rule, I'm going to go back to Uber Eats really quick.
Yeah.
So, the whole concept of Uber Eats is basically you want food, but you don't want to go out and physically get it.
Yep.
Right? So, you want the food really, really badly.
Yeah.
But then you also really.
The predominant purpose is clearly the food, and yet they're not really the ones providing the food. That's why the split between the restaurant and the driver was such genius, right?
Is that the thing where it's
Yeah.
you could really truly argue either way because
You really, truly can.
It's like, let's say that I really don't care about the food that much, but I really just don't want to leave my house.
Yep.
That's it?
Yep. That's it. Predominant purpose. By the way, the minority rule is even dumber, and that's why this is the majority rule. The minority rule here is called the gravamen. Gravamen means the gravity. The gravamen of the action is just whatever the plaintiff pleads. So then they can just plead whatever they want. And most courts are like, okay, no. We're actually going to go with, because you're saying, what's the real thrust of your argument? Are you mad that the pen was deficient? Or are you mad that the design was faulty? That one's even less determinable.
So you're just trying to convince the judge that you really, really didn't want to leave your house or you really, really wanted the food?
Yeah.
Okay.
And the reason you're doing that is not because you actually believe that. It's because one of these outcomes gets you a better result under the law that you're trying to get to. And so you write the affidavit for your client, and you're like, no, I was really, really hard up for food that day. I didn't care where I got it from. I could have got it from the store down the road. Instead, I chose to get it through your online site or service. This is clearly a UCC transaction in hamburgers. Or, want me to do it the other way? I will take money and I will sleep very well that night. Okay. Gene.
So I had thought of another ways of really serious, and maybe little 2010s to me, but those couponing sites.
Yep.
Where you could, and I know there was a huge case about it at one point where you could just get coupons from them, but there was a service that also giving you a product.
But also giving you a product, and by the way, it also crosses into false advertising, et cetera. Yeah. Look, y'all, this is the basic discipline of a lawyer, is to take facts that don't fit any of these boxes. They're never going to fit exactly. That's not the point. The point is to find the boxes and then be like, okay, if I put it in that box, this happens. If I put it in that box, this happens. If I put it in that box, this happens. And so you make the arguments. Every time you are fundamentally confused about a rule, good, because you know the rule and you know the ways that it can work out. That's called being a lawyer. If you pick one, you win half the cases. I hope to teach you to do better than win less than half of your cases, right?
Earlier you agreed that selling a hamburger is a service. I don't know how you can, maybe I misspoke, but I don't know how you can justify that because no one's going into McDonald's for the sole purpose of a greasy teenager making a burger.
Right? Clearly. And yet, can anybody give me a circumstance in which clearly a service? Well, so they want somebody else to make it for them. That one would be like just obviously off on this side. That's called something that might be on the bar exam, but it'll never be on my exam because I'm always going to pitch it down the middle, right? So yeah, you could move it over there. Can you move it in a restaurant? Has anyone seen The Bear? Okay, give it to me. In a restaurant, sell me that it is under the common law and not the UCC, and use an example from The Bear. Or to not. If you don't want to use the plum reduction that the guy does, you don't have to use the plum reduction that the guy does.
Well, like if there's like an esteemed bartender who like makes a cocktail a certain way and there's an art that carves ice sculptures and dumps them in your drink, that's a service.
Yeah, that's clearly, and when I say clearly, I mean what you've done is made a pretty persuasive argument on one side or the other. I do not mean it is obviously and only that thing. A competent counsel on the other side is absolutely going to have a field day with this, so you better be good too, right? Both parties are going to be doing this as hard as they can, this characterization game. All right. Any further questions on closing this out?
No.
That's just another dangerous pen, okay. Yeah, Scott.
This is maybe going in a different direction, but think about the difference of these two boxes.
Yes.
Is UCC generally more settled, which is why we see fewer UCC cases in the book, whereas common law is more, there's going to be more future lovers down the road? Or is that just kind of...
No, it's for two reasons. One, because the UCC is rapidly becoming antiquated because we are two economies after the industrial economy. And because we can't update it because we do not have a functional policy and legislative system in the United States. So we can't update it. The process by which we used to update it has fundamentally failed. And so we're stuck with basically rules from the 1970s about factories. But the second rule is because it doesn't apply anywhere nearly as broadly because it's about movable stuff, and most of the stuff we sell these days isn't movable stuff, it's stuff online. It's basically the same answer twice. The internet. Anything else? On the predominant purpose. So there's a bit of a sidetrack into the predominant purpose rule, but since I ask you all the time, what law applies here, and you should probably begin asking at this point, this is why like I thought your sort of point in calling this a subscription was brilliant, and that's why we went here, is because you'll notice all of these, if you really look at them hard enough, you're like, I could call that a service, I could call that a good. Don't get bound up when the court says, this is a sale of goods. Just be like, I could win this for the other side. This is clearly a service. No, it's not. Bet I could win that one in West Virginia on a Wednesday, right? Okay, cool. All right, what I need you to know out of that is the predominant purpose test. But we are back on this after an extended segue. What are our two characterizations? Because one of them is more kind of common law. This is all under the UCC. I get that, because this is food, movable. But one of them is more common law E. The other one's more UCC E. What are our two characterizations? Yeah, that is, they were claiming it's a firm offer, not a contract. And if it's a firm offer, then what?
Then after 3 months, well, it says either after the time stated or under a reasonable amount of times which the UCC deems as 3 months, then the offer has expired and therefore does not count as a valid contract.
Does not count as a valid contract. What's the role of writing in all this? Because both of our characterizations are going to have to struggle with writings. And how does that work? The idea that they keep saying it was not written, right? That the price increase was never written.
Yeah, it's saying that, I believe it said that it was not necessary for it to be written. Right?
Not necessary for it to be written? How do we decide if something is necessary for it to be written? Statute of frauds. Anybody want to blow me out of the water and tell me what the statute of frauds is here? Does this apply under the statute of frauds, under the UCC? What's that?
They're big purchases.
They're big purchases. Wait a minute. How big are these purchases? Over $500. You better believe it. Do we need a writing? We do. The part that's going to catch you by surprise is, do you need a writing for a modification of a contract? Because they had a contract already. Do you need a writing for a modification of a contract that's over $500? I'll just tell you, yeah, you do. Just like you need it to get it in writing for the contract in the first case. If you're going to change it, to modify it, and you also need a writing to modify it. Never mind that most of these contracts say all modifications must be in writing. That's also a standard thing that all of these things say. So the one side is doing this one time, then one time, then one time. That firm offer goes for 3 months. then it wears off, and the next price increase is the next firm offer, and the next price increase is the next firm offer. Do you see that characterization? We're finding another lever here, that characterization between their relationship as a series of different contracts. You see how that works? Now, if these are a series of different contracts, then how do we characterize the price increase?
That it's a secondary offer, so it's no longer.
Well, right, the first price wears off, which means that when I charge you the second price and you order, then what happens?
You're accepting the deals.
Yeah, you're accepting the deal with the second price, right? Third one, right? Let's say that one wears off, and then you do a third one, right? And you accept shipping there. What does that let them do with respect to the prices going up and down? Characterizing it as a series of one-off transactions. What does characterizing it as a series of transactions do with respect to Mid-South's ability to say, yeah, we need to charge you different prices at different times?
It's saying that since the first one is no longer viable, that they didn't have to wait the 45 days.
Yeah, they didn't have to wait the 45 days. They could just give another offer at a higher price. And when they accepted that one, then you locked in that higher price for that period, right? How does this characterization change? What's the other big characterization they could use?
The other one, Shawnee's claimed that it was a requirements contract, and therefore it was for a long period of time.
Long period of time. Now, what is the legal characterization? If the court buys that this is a requirements contract, I will buy all of the chicken nuggets or whatever from you that I require. First of all, is that supported by consideration? I will buy all the chicken nuggets from you that I require. Is it supported by consideration? Absolutely. Why? Good faith. Well done. Just reminding us of that. Okay. So yeah, it's supported by consideration, but that wasn't what we asked. What we asked was, what does it mean if we call this a long, not a series of one-off deals, right? But one long deal.
Then therefore they wouldn't have waived the 45-day rule, and Mid-South would have had to wait those 45 days in order to do it.
Is the 45-day rule applicable to this at all?
And if it was a requirements contract, it still would.
Yeah, you're not gonna be keeping the price open for the whole period of this long-term contract. That firm offer rule isn't gonna really apply here at all, which means that if we need to modify the price of the requirements contract, what do you need?
You have to wait that period of time in order to modify it.
Well, not just wait that period of time, you need it in writing. Do they have it in writing? No. Do you see the argument that's being made, right? If it's a series of transactions, then these are just considered firm offers that are accepted, right? But if it's a longer requirements contract, then it looks like they would have to get that response in writing. I'm going to ask the trick question. I'm telling you it's a trick question. I need an overwhelming universal response in order for me to feel validated as a human being. Which is it? A series of one-off transactions or one longer requirements transaction? I am so hurt. I'm going to ask one more time. I'm hoping for a different response. Which is it?
It depends.
There we go. It depends on what?
What side you're on.
What side you're on. Okay. I'm feeling heard now. If you think that this is, I'm here to tell you, this is a very weird characterization for the firm offer rule. It's weird. It's also kind of weird for requirements, but it's probably actually closer to requirements than it is to a series of transactions. We have a supply contract here. They're ordering every month. To call this a series of different contracts is pretty dodgy. I need you to see two things. One, can you see how to jerk that lever? This is a big deal, y'all. It's not the rule that we're even looking at in here. In this case, it is a tool you will use throughout your entire contractual career. You can characterize a set of relationships as a series of one-offs, or you can characterize it as one big contract spanning all of the examples. And that characterization between a series of one-offs and one big contract covering all the examples often profoundly changes the outcome of the case. I almost care, in fact I do care, about that far more than the black letter law of this case.
Yeah, but didn't it say in the actual case that Shoney's could have, they had the right to change the suppliers and by their own admission, so they couldn't, it couldn't have been a requirements contract.
Yeah, the question is then, is that still constrained by
Good faith?
good faith? If they can just change it at any time, it can't be a requirements contract. Oftentimes, though, there'd be enough constraint there if industry rules, like if there's a lower price guarantee rule where they say, I have to buy from you, but if you decide you get a lower price from somebody else, you can go to them. That still is an option that needs to be exercised in good faith. And we will see that rule set up later on when we get to good faith. But it turns out good faith is defined as when you've got an option under the contract, you can't use it in a way to deprive the other party of the benefit of their bargain. That's what good faith means. We're not going to get there for a minute. But you can see what they're doing here, right? If they are double bookkeeping, then they are depriving the party of their ability to make the price increase as negotiated. They're depriving the party of the benefit of the bargain. If they didn't want it, they shouldn't have agreed to it. All right, great question. Any other questions on this one broadly? We're going to move out of it pretty fast. Annika, yep.
So Mid-South said that the price increase in this instance was due to computation error by them.
Uh-huh.
Could Shoney's use this as negotiating?
Yeah, sure. If there are provable mistakes being made in the contract, then we will see rules later on. Remember I said our 3 M's? We might have said the parties didn't sufficiently agree on a contract term. Therefore, restatement 20, misunderstanding the Raffles versus Wickelhaus rule. We never agreed. There was no meeting of the minds on the terms of the agreement. Which is, by the way, what this is doing in the book. The book is still talking about negotiation and the differences of opinion between the parties during that negotiation period. That's what it's talking about. But later on, we can see that there are defenses involved. And one of the defenses is unilateral or bilateral mistake. One party made a mistake. And so you might be able to push back and say, I think it would have been a better narrative for them than, yeah, we agreed with it to get it shipped, but then we just did double bookkeeping. And it would have been better for them to say, well, wait a minute, no, we just thought it was a mistake. And it turns out it was a mistake, Your Honor, and so you should rectify the contract in the direction of the part of the mistake that they made that we relied on. Right? Yeah.
Just a clarification question. Don't firm offers also have to be in writing?
Yeah, but the purchase offers were. It was just that the acceptance of the term wasn't. Right? They were communicating the prices with the invoices, and they. But yeah, do you see the court going, rudder, hard over, and the ship's like leaning, right? It's like Master and Commander, that movie, right? Other side of the world. Boom, the whole ship is just going because it's taking those invoices and it's recharacterizing them as firm offers using the firm offer rule to get to this result. If your response is, wait a minute, that's the court doing some pretty heavy lifting for some reason or another. Why are the court doing all this heavy lifting? In order to keep regular business practices. Liam?
So they don't get overturned later.
So they don't get overturned later? Because they're liars and assholes. That's the answer. It's because they're liars and assholes, and that's why the court's going to all this work. All right. Further questions on that? Yeah.
So all this falls under UCC, right? Each the requirements versus firm offer falls under UCC.
Yes, all that falls under UCC. Both of those, the firm offer rule is 2205, right? The requirements contract rule is 2306. These are both UCC rules that we've gone over before. Okay, we spent a pile of time on that, but I think it was well worth it, especially because it gave you the rule of predominant purpose. Unfortunately, the next one is also going to be a bit of a rough one. And this has to do with AA builders. There's some work in between. I sent it to you in the agenda. I'm just going to touch on these because you don't need to hear me lecture what you've already had sent to you. So when we're talking about revocation of the power to accept an offer, that's terminated at a time communicated. If you have a week to accept and it's 8 days, you are outside of your ability to accept. That's the revocation of an offer. So it's going to be either a time set in the offer that will limit your ability to do that, or to revoke the offer, or a court will sometimes say it's held open, an offer is held open for a reasonable period of time, but it's not going to be considered indefinite. Anybody want to give a crack at why a court will not leave an offer open indefinitely? Yeah, it's a free option, right? Tell me why.
Because time isn't constrained.
Yeah, because time is not constrained, and against market movement, unlimited time means unlimited ability to screw the other party. No, Not going to happen, right? So the courts will impose that reasonable time limit. That's exactly right. Yeah.
Just clarifying, is this the restatement, section 41?
This is 41.1, yep. And the offeror can withdraw it at 42 then. And then there's the offeror, even if they don't withdraw, if the offeree gets information that the deal is off, then they lose the power to accept. You'll see that on the bar exam sometimes. 2, usually the way they do this on the bar exam is I offer to sell you my car. Before you accept, you learn I have sold it to someone else. That's the usual move. That's what they'll put on the bar. And the idea there is, even though I never formally revoked my offer, you became aware that that offer was no longer open. And so therefore, your ability to accept has been terminated. So there's the termination options there. And then we're going to move to restatement 87, which I think we've already done, right? Restatement 87.1 we did in Laporte versus Blum. Just to remind us of what restatement 87 is, it is taking restatement section 90, which is promissory estoppel, and it's taking it away from its core use as promissory estoppel, detrimental reliance, and is starting to use it as a contract patch-up doctrine. And one of the first places we saw that was in Laporte versus Blum, where they used 87.1 to patch up consideration because it was not clear that the parties had ever swapped $10 for the option. They said they did, but they hadn't. And so that's what 87.1 is about, is saying we will enforce an option if there is a recital of consideration, even if there's been no consideration. We are then moving to AA builders, which in its language, and the reason I'm lecturing here a little bit is because this can be confusing. In its language, it says that AA builders is about restatement section 90, promissory estoppel. But it's not. AA builders is the reason that we have restatement 87.2. That is, at the time of the case, AA builders didn't exist. I'm sorry, the rule didn't exist quite this way. But 87.2 was because of many cases like AA builders that we made that rule. And so we made a new rule. As you will see, AA builders isn't actually a restatement section 90 case. It's a court taking restatement 90 and mutating it. And by the time it's done mutating it, it becomes the law of restatement 87.2. So that's the black letter law of where we're going with AA builders. I say that because we're going to have some work to do in AA builders. I'll ask a couple of people to do it. Let's see. Leland, would you mind setting up AA builders for us, please?
Sure, I do, sort of unrelated, I just want to say I hate the double and then also putting AA.
Oh, I know. Oh, yeah, no, pick a lane, sure. One of many reasons to hate the case.
So AA builders, the Grand State Construction, AA builders is the GC building a new Home Depot in Mesa, Arizona. Grand State Construction is the subcontractor that had sent them a faxed but unsigned bid to install the insulation finish system in their new Home Depot. It said on the bid that it was good for 30 days. It was the lowest price that they had. AA went with Grand State's bid, submitted it to owner, which is Home Depot, while trying to get approval for the project. Home Depot gave them the bid. So now AA is rolling with Grand State for their EIFS. They reach back out within 30 days with a subcontractor agreement, and Grand State says, whoa, I was just kidding. I'm too busy now. I'm not going to do that for you.
Right.
And they're like, hey, it's been less than 30 days. This was an offer. We have an offer. So they originally go to an arbitrator. Arbitrator sides with subcontractor, and they are appealing for trial de novo. They win in trial and are awarded the cost difference between the bid from subcontractor and what they had to pay a different subcontractor to do the work instead. And both sides wind up appealing. Subcontractors appealing for judgment in favor of the GC. GC is appealing because they want subcontractor to pay their attorney's fees.
Yep, and that's where we end up now. Okay, let's go with just a brief moment of black letter law, and then I'm going to ask you which side you want. Riley, you're on deck for the other side. Let's do the brief black letter law. What's the black letter law of this case? What does it think it's talking about?
Whether there is promissory estoppel in a case of the GC relying on the subcontractor's bid.
Right. So you've got a general contractor. They're working with the client. They send out a bunch of subcontracts, right? And then those people all make bids, and then those come into the general contractor, and the general contractor writes them up into the bid, and then they put the bid in with the client. That's the framework we're dealing with here. Okay. What's the clearest reasoning that lets you use Section 90 promissory estoppel to enforce this? What's the reliance?
You relied on their offer in submitting your bid. You can't, it sort of addresses it with saying, hey, if we're allowing them to just back out of this at the last minute, it can turn projects into being unprofitable. It's bad for the entire industry. It's bad for the market. And it also kind of aligns with the moral theory of just sticking to what you tell people you're going to do.
Sticking to what people tell you to do, which is pretty textbook to promissory estoppel, right? Okay. Does everybody see that's the black letter law of the case? We could walk away if something didn't stink here, but we can't because something does. But I need you to see the black letter law right now, which is the court starts with Section 90, it ends up with Section 87.2. 87.2 says an option is enforceable if somebody relies on it, if in the absence of injustice. I am here to tell you 87.2 does not apply broadly. If it did, there'd be no such thing as accepting a contract. We would just simply say, if you would like to accept a contract, rely on your partner. Right? It's like those have you ever seen the YouTube videos of those people with the flying suits? Where they leap off of mountains and they're going down and it's you're gonna hit the rocks, and then they barely miss and sometimes they don't. By a split second, right? Can you imagine if that's the way to accept a contract? Hurl yourself into the void, right? I trust you, woo! Instead of actually negotiating the damn deal out and shaking hands, right? Okay, well, you can see the problem with it. 87.2 applies to the building industry only. That is a matter of freaking fact. That restatement rule does not get broadly applied, except we will see that somebody then got high one evening and applied it to the UCC, but we'll deal with that in a later case. Where you were I believed you, and that's how you accept a contract. I swear on a stack of whatever you hold holy. They just were yeah, I believe you. That's how you accept a contract, instead of, I don't know, saying, I accept your contract. Okay. That's the black letter law. Any question on the black letter law before things are about to get ugly? Okay. Leland, which side do you want?
Do you mind if I take GC's side?
As in the plaintiff?
Yeah, go for it. Double A.
Okay, so so we've already heard your state. So you're taking the GC side, right, on promissory estoppel? Okay. What's your best pushback on this?
Why didn't you tell me before you accepted it to just confirm if I was still available? Time had gone by. It's your due diligence.
Time had gone by. You should have told me. Your response is?
You provide a 30-day buffer window. We have to get bids together. We have to get approval from Home Depot. We responded in a timely manner. If you give me that window.
If you give me that window, I get that window. Riley, we got to dig deeper. It's not just giving them the window that's the problem. What is it? What do you call it when somebody gives you a window?
What do I call it? I mean, it's an open offer.
Yeah, well, open option. It's an open option is what it is. Now, you gave him an option.
Yeah.
Does that help you at all?
I could argue that it was a free option and that...
Yeah, it was. What did he give you in response to that option?
Just a minor guarantee that maybe I'll get work, but he gets to walk away at any time.
Which means if you're bound and he's not, we call that an option. What's something else that we call that?
Illusory contract.
An illusory contract, or, well, it can be a unilateral contract. If you're right, there's another form of unilateral contracting, which, let's just talk for a moment about unilateral contracting, because I hate it so much that I want to get us out from underneath this. What's a unilateral contract?
It's a contract created by an offer that can only be accepted
By performance, right? So you can imagine reward $50 if you find my dog. Right? Now, that seems to create an option, which is what? What would, if you were to characterize reward, $50 if you find my dog. So somebody starts going and looking for the dog. You only get the money if you find the dog, if you bring me the dog. What happens if, like, I see you with the dog and you're about like half a block away and I'm like, I revoked the offer! Which, by the way, is the core problem. Do you see how unilateral contracts almost always create this option problem? Anybody know the black letter law that constrains that? That stops you from doing that shit?
So once the offeree starts performance of the action, the offer can't be revoked.
That is what they do in that circumstance. Because unilateral contracts create this problem, you're absolutely right. What that does is the court has to tack on a rule locking the offeror in once the offeree starts performance. They give them the ability to complete performance, because otherwise it would just be heads I win, tails you lose, right? So we're going to see this same move here. We're just going to have to transpose it a little bit, but watch for it. There's an option. What the court ends up doing is the court is going to constrain one of the parties using promissory estoppel. By the way, the court doesn't constrain the other party using promissory estoppel, which becomes the major problem and why AA Builders is a stupid, stupid, stupid case. As anyone who's actually involved in the construction industry will be able to tell you, like, AA Builders is not popular with subcontractors for a reason. Okay, so does that give you anything? You gave him an option. What's the legal character? I'm fishing here. What's the legal characteristic of an option?
Oh my God, I love being on the spot.
So, I can tell you're thrilled.
My favorite. Legal characterization of an option is, I mean, the benefit to me is knowing that I might get the sale.
Oh, yeah, but you're handing him tools.
Yeah, okay.
Without that benefit to you,
Yeah.
what argument do you make? What argument do you make out of there is a benefit to him? There's actually no benefit to you, right? He is not bound to hire you.
The benefit to him is he gets to talk to 1,000 people who are just like me. He can even use my offer as a negotiation.
Yeah, he's not bound at all. And by the way, you hit the real problem with this after AA Builders. What actually happens with the rule of this dumb case is that it's called, did you see it in the notes? It's called bid chipping, right? That's actually the function of what the court does. The court says, I'm going to bind one party and not the other. And so what that means is that GCs are like, yeah, nice bid you got there. Would be a real shame if something happened to it. You know, I can go with anybody. Better lower that bid or I'll go with somebody else. And then subcontractors have learned to pad their bids so that they can go down during the chipping in order to be able to handle the chipping problem, right? So the court thinks it's fixing a problem, but it's like whack-a-mole, right? The court's like, I'm going to whack that option, and it pops up over here. They're like, damn. And that's sort of where their analysis ends. But I need to get to the technical argument. The technical argument is, wait, whoa, hang on. Under the common law, by the way, I just blew it. What law are we under?
Common law.
Yeah, sure. Right. Under the common law, what do we generally say about options? Let's say you gave him an option under the, like, let me.
Close in a certain amount of time, but that's not what you mean.
No.
I don't know, co-counsel?
Co-counsel. That is, either there is consideration, because if there isn't, it's free and it's utterly unenforceable. That's the point.
Yeah.
Options not supported by consideration, generally, under the common law, are completely unenforceable. They're completely unenforceable. That's why we need things like the firm offer rule to make them enforceable, because otherwise, the whole point of an option is it takes the form of I'm bound and you're not. And if I'm bound and you're not, is that a contract? No, it violates what basic concept? Consideration. It violates the form of both parts, something for something, right? It is actually something for nothing. In this case, the subcontractor is bound, the contractor is not, and last I checked, we were under the common law, which means this is completely beeping unenforceable as a matter of contract law. And by the way, if you were the Lelands of the world and you really wanted this arrangement, what would you do? If we said promissory estoppel is a completely damn foolish way of handling this, which is true, Promissory estoppel is a stupid way of handling it because it creates the further problem of bid chipping. What would he do?
Give me $10.
Yeah, give you $10 for it, right? Like just pull that Lucy versus Zamer. Give him some consideration for the option, lock that option in, then you've solved the problem that there is no consideration for the option. Cool? Cool. Okay. But what you've pointed out so far is, Your Honor, this is another failed contracts case. He had every opportunity to bind me to this agreement. If he wanted to, what should he have done?
Offered some type of consideration.
Offered some kind of consideration for keeping the option open. He did not. Therefore, my offer is entirely unsupported by consideration, and the law deems that to be something for nothing, and we don't enforce something for nothing deals. It's a pretty solid argument.
Yeah, and the defense, like, the way they sort of describe themselves is an expression of desire and not a promise.
Yeah.
I wanted to do the job for that amount of money. I wasn't promising.
Is that the place to focus? Is on your desire to do the work? Or where should you focus?
You're losing me.
Because you say the obligation's less, you said it was my desire to do the work, not an obligation to do the work. Is that the right person's obligation to talk about?
Well, if you're talking about your desires, then that could fulfill your consideration.
Well, see, that's the problem, right? What you're doing is you're handing Leland the tools to say, which is what I do mean to say.
Satisfied me.
Yeah, it would be that, well, and let's do this for a second. So what I'm reaching for here is this, that we're not really talking about that it's a mistake to talk about your obligation, because that's never the problem with this arrangement. The problem is that Leland's got no obligation. He's not bound, you are. That's not how contracts work. This is a failed contracts case, big surprise. This is a failed contracts case again. The parties should have had a contract, could have had a contract, chose not to have a contract, and are whining to the court about it later. And that's the most powerful rule, and like Riley's nailed that. That's the most powerful argument that you can raise here. Leland, what's your pushback on that, though, to say that this, if you sense the court going that way, you say, 1, Your Honor, we should win on promissory estoppel. 2, Your Honor, if you think this is a failed contracts case, actually this option was fully supported by consideration, how would you do it?
The consideration is that they want to do the job, and if we win this bid, we are going to be hiring them for the job.
And love that. So that's consideration, the increased chance of being considered for the job, right, is the consideration. Riley, your response to that, do you notice he made a critical mistake? He said, here's the sentence he said. He said, I'm going to fix the lack of consideration problem. And the way I'm going to fix it is by saying the consideration for you in extending the option was that you would be considered for the job, and that if we get the general bid, the consideration in my direction is we have to use you for the job. Now, one of those sentences is true. You don't, like, nice try, but you don't have to use him for the job, so that's not actually reciprocal obligation. What I need you to see here is why they went to promissory estoppel. They went to promissory estoppel because there's no way in hell that this is an enforceable option at contract law. In fact, they can't get it enforced at contract law. And then they do it as reliance, and we've done the black letter law here, and I think you all understand how they think that the general contractor relied on the subcontractor in order to put their bid through to the overall client. And if you did that, by the way, what's the position of, let's make the GC look better. What's the GC's problem if the subcontractors are not constrained? Right, so that's the threat, and then we can generalize it. Because what happens if you can do that? If one subcontractor can do that?
And they all can, and then the GC is bound by the cost.
Right, so then if one can, they all can. And if they all can, then your production cost is going to be well above your cost to the client, especially since your bid to the client was the result of a competitive process as well, right? You got it because you were the lowest bidder. Fine, but you're not going to be the lowest bidder for long if all your subs keep doing this. You see the problem that the GC's got? Okay, cool. The court sees that clear as day 2, says, I get it. I can't solve this problem with contract law because there is no consideration for this common law option. Yeah. So they can't do that, but they choose restatement 90 to bind one party and not the other. And then, Riley, go ahead and sort of wrap it up with your initial intuition. This can't be the way it is because all we've done is displace the problem, the threat to the GCs, but now we've displaced it down to the subcontractors.
Yeah, anytime this happens, you can just take my offer and show it to all my competition, undercut me, and I don't even get the promise of
Yeah.
getting to do the work. There's
Yeah, exactly. And it gets much worse than that because
they can also then come back to me with that and keep
and keep going back and forth. And also remember, it takes time and effort to work up a proposal, right? And so let's say you go do that. You go to the time and effort. You're like, okay, what's the cost of this wire? And I put all this together, labor costs, da, da, da. So you put it together, boom. Can you see that Leland can offer that deal to somebody else who can always undercut you? Why can they always undercut you?
didn't have to spend weeks with a bunch of actuaries doing this work.
Right, that is, they've got the material and labor costs, but not the cost of developing the bid, which means that every time they can chip you, right? And so the court solves this problem by using restatement section 90. It's a stupid move. It's a stupid move because all it does is displace this risk of uncertainty onto the subcontractors in exactly the same format. Can anybody give me a rule? This is nowhere the law, but I can't leave this without actually trying to make the law better here. What would be a sane rule for this space?
I like the idea of having to include the subcontractors you'll be using in your bid
Yeah.
to the owner.
So
because then you're
if you put them in the bid, then what's the next thing?
No, I completely disagree.
Cool, we'll get to that in a minute.
And the general contractor is bound to use that.
Then if the sub gets put in the bid, then the general contractor is bound to use that sub. That is, the obligation should go both ways. If you get the bid, if you accept them for the bid, and if you get the bid. Now, why?
This is gonna slow down the whole process. Nothing's ever gonna get built. The whole point of them, like, the Home Depot going to general contractors is because they don't wanna deal with going to all these people to build all these different things. So at first you're gonna have to collect your subcontractors, and then the general contractors are gonna have to fight for the bid. That's just gonna
But that's what they're doing anyway.
Yeah.
That's actually how the system works.
At the same time, he's saying that they should have like their subcontractors lined up first, and then you compete.
That's what this case absolutely contemplates. They contemplate that the subcontractors put their bids in. You're right, sometimes the construction industry works differently. But they're contemplating that the subcontractors have their bids in, that the GC builds the big bid out of all of the subcontracting bids, puts that into the client. There's the bidding process there. If they win, then the question is because this is the problem that Riley raises, if they win, is the general contractor obligated to use the subcontractor under the restatement section 90 approach? They're not, which means that after the GC gets the bid, the GC can come back and say, hey, remember that bid you put in? You better lower it. I'm going to go with somebody else. But you're right, it does change if the GC is trying to change subcontractors or is trying to put the bid together out of bids they get after the general client bidding process. That's a good point. Yeah.
I was gonna say a potential solution as well, that just stealing your idea that you gave, like putting down $10 and creating that contractual obligation.
Sure. And by the way, is it going to be $10? Like, let's get our economy on for a minute.
Yeah, it's probably close to 1,000.
It'll be closer to 1,000. Like, how would we determine that price?
Maybe it should be close to the amount that they spend putting the bid together.
Close to the amount that they spent putting the bid together. That's a pretty solid one right there. They're out-of-pocket costs. Yeah.
Is that percentage of the bid cost?
Yeah, I like all of these. More. How else might you determine it?
It should be calculated based on probability. What they felt.
Yeah, it's going to be based on, this is going to be a market analysis, pretty much like any other market analysis. You just look, how much would you pay for an option to buy Bitcoin at $100,000 in 2 weeks' time? I don't know, look at it, right? It was 123 a while back, and now, right? So you guess based on the market. So that's what it's going to be. It's going to be like, you pay me for the uncertainty that you want in the freedom to not use me if you get the bid.
Yep. And for the quality of the deal I'm offering.
Yeah, and for the quality, exactly, yep.
Isn't it kind of like a catch-22 though? Like, not to, poor little GC or whatever, but like, if
GCs are
every
people too.
GC has to pay every subcontractor a percentage of the amount it costs to put together the bid, and then only one GC wins the contract. then-
Yeah, but I mean, they also got to pay employees to write the bid up and to do the actuarial stuff. Like, these are costs overall, probably going to be competitively priced into the bidding process. Which is why the GCs, by the way, ironically and hypocritically, get super pissed when they put in a bid, and then the client, we'll see in a later case, pulls the same stunt on them. Oh, they hate that. They hate that. The client takes that bid and goes shops it around to their buddies and gets a lower bid, right? And we will see a later case where a court's like, oh, that's totally unfair. We will use detrimental reliance to enforce. And you're just like, y'all, how about we just make this contract doctrine? If you are introducing uncertainty, if you would like an option, pay for it.
I don't know how to solve this, but I do know that God is popping balloons.
Oh yeah. No, there are definitely, that is, all of these are transaction costs. The uncertainty, right? The uncertainty here that the subs have to use to pad their bids, and the uncertainty as to whether or not they will get the deal, all comes out as transaction costs. The uncertainty is a transaction cost, and that means that deals that should have gone through won't. Nate, there's another really big transaction cost problem here, but we're just not going to have time to talk about it. But it basically has to do with one person negotiating with many always has higher transaction costs than many people in one direction than one person negotiating with one. And so that one-to-many scenario is one that you should keep in the back of your head to go, the court may well do something to solve the fact that it's just harder to negotiate with a lot of people. And in that case, they may give a benefit to the person who's the one in order to give them, to stop that problem that we noticed earlier, which is if everybody raises their bid price, the deal falls through. And we're going to leave that there. Any final black letter questions? We'll leave the theory. Any final black letter questions? This is section 90. It becomes section 87.2. An option is enforceable where to avoid enforcing it would be injustice if it has been relied upon. But I'm here to tell you that 87.2 is only in the building industry for reasons that we've discussed, and it doesn't solve the problem. It just displaces it from the GCs to the subcontractors. Cool. Then let's move on. All right. So we got to talk about Sandoval. And flip through here. Kristen, would you mind setting up Sandoval for me, please?
So the defendant, Sandoval, was a teacher employed with district in Kansas. She was informed she was losing her teaching contract.
Yep.
And during the March 10th board meeting, multiple offers were made between her. She was represented by somebody from some education association as an attorney, and he made multiple counter offers with the board as far as her insurance, how much paid leave she would get, and disability amount.
Yeah.
Disability or not. And after the counter offers were exchanged, she informed her representative that she accepted final warrant of paid insurance for 5 years, 180 days of paid leave, and 20,000 if she qualified for disability. And the representative let the board know. But 2 days later, after her representative and the district's attorney were exchanging draft settlement agreements, Sandoval told her representative that she changed her mind and she decided that she wanted a due process hearing. And the representative told the district. The district shortly after sent Sandoval a letter saying that he thought an agreement was reached and the board would not renew the contract on April 14th, which was the next board meeting. But Sandoval showed up to her job on March 28th, which I think was the date that she was supposed to not show up. And she finished out her teaching assignment, and they never sent a substitute or anything like that.
Okay. What's the court decide?
The court decides that that contract, well, they decide that that contract in the contract that there never really was a contract in the beginning when she accepted it.
Okay, which I love you're putting there together because let's just sort of stop anything else for just a second. You read off the facts of the case, and you're absolutely right. And this is sort of the moment you paused, where you said, like, and she accepted. Period. And every hair stands up on the back of my neck. What's the state of affairs at that point?
Well, you could say that the state
There we go. Love this. I'm so happy I can barely breathe.
you could say that the state of affairs was that that was the contract.
Yeah.
The oral contract. She accepted it unconditionally. But she argues that based on the actions of the district after that, it shows that there wasn't.
There wasn't a contract after that, right? Which we got to get into. But to start with, right, if you're arguing it from one perspective, she accepted, full stop. Let's just test that. What law are we under? We're absolutely under the common law. Tell me why. Teaching is a service. Well done. So under the common law, then we're now under the common law. Cool. What about all this language about like they didn't write it up and they didn't sign it? That's exactly right. Under what circumstances, I know we're skipping ahead to formalization, under what circumstances would they need to have a writing to memorialize this agreement? If they don't,
Yeah,
is my point.
they kind of do.
What?
They kind of do.
Oh, preach.
Because of the district.
Yep.
The district has something that says that you have to put it.
Sure, but I can have like policies saying like I win every time we play a game of poker, right? Like that is my firm policy. Enjoy, but like that has nothing to do with anything. You're right, the court, they do bear down on that, but what I'm trying to see here is under what circumstances would they need, under the common law, would they need a writing? Yeah. The contract term is longer than a year for a service contract. And to be clear, and I'm going to use this language intentionally because otherwise we run into the Death Star problem, which is although the Death Star clearly takes more than a year to build, it is possible to build it under a year. And so I will use the language, contracts which by their terms cannot be performed in under a year. This is a contract which by its terms absolutely could be performed in under a year, which means our oral contract is looking pretty hand-wavy at this point. We're like, yeah, you might not need it. Yep.
What about the fact that they said that they would pay insurance in the bottom tier for 5 years?
Maybe, I love it, right? But she could, as long as we're on this tangent, let's come back the other direction. Say, well, wait a minute, an idea that you will pay insurance for 5 years doesn't make this teaching contract a contract which by its terms cannot be performed in less than 5 years. It's a brutal question. It does make it a lot longer. What's your argument that actually no, this contract could be performed in under 5 years?
I'm saying, like, I mean, you can just give the insurance money. Here's the upfront money for 5 years. Y'all handle it.
That would be one thing. You could just pay it up for 5 years ahead of time, yeah. She could die. She could die. She could leave. Y'all, this happens all the time. Why is that different from our franchise agreement in Midwest versus Orion? Because there's another way of characterizing this contract that's flavoring everything that's happening here. It's a separation contract, but the underlying agreement is for...
Like a human?
Yeah, that is, and what do we call it when you're contracting for humans to do what I am doing right now, which is work? No, absolutely goddamn not. No, we call that employment, right? These are employment contracts. What do we know about employment contracts? Our employment contracts, if I had a contract to work for W&L for 10 years, what do you suspect is true about that? It is written and signed, yep, it's also true. Yeah, that even if it's a 10-year contract, either party can leave at any time for reasons that have been previously mentioned about 30 seconds ago. That is, we don't hold people to these. Either party can usually terminate at any time, right? So this makes it a hard one. It's probably true that this contract could be fulfilled. Like if they were going to pay for 5 years, she could die. It's a contract for services. If it was a contract to hold her on for a certain period of time, that could be performed in under the 5 years. I'm not saying don't make the argument. I think it's a brilliant argument. There's a term that must run over a year, therefore you must have it in writing. That's much better than the school districts. We have a contract, we have a policy that all of our contracts must be only for $1 or whatever the hell they're saying. Because if they do something different from that, then we listen to them when we do something different from that. Like when they violate their own policies, I don't care what your policies are. You just did this, right? But I think it's a brilliant argument. I think you should stick with it. I'm just talking about ways of pushing back on it. Why this 5-year term might feel a little different than the 5-year term of the franchise agreement. 5-year franchise agreement, you will have the franchise for 5 years. It cannot be performed in less than that time. Okay, cool. All right. Then what does the court do with this, right? The big problem of the case is that lovely kind of pause that you gave after, and she accepted. What's the court do after that and why?
Well, they consider the actions that surrounded the agreement. So, like for example, they didn't send a substitute. The draft settlement agreement could be considered like going back and forth. There's still counteroffers going on.
I love that there's still counteroffers going on as this thing. Do you see that legal characterization? Where are we in the negotiation versus contracting process? Is there a contract or not? Oh, thank God. I was going to be so crushed. What's it? That is let's say that there's clearly not a contract.
Yeah, there's clearly not a contract because part of the agreement are these separation terms like, I think they said, like disclosures or not disclosures, like, I don't even remember. It was just a bunch of tiny little things. Yeah.
Clearly not a contract because they left so much stuff open.
And all that stuff still has to be negotiated.
Clearly a contract because... Clearly not a contract because they left so much stuff open to be negotiated later. They hadn't agreed on all the terms, right? Clearly a contract because there was offer, acceptance, and consideration. Meeting of the minds on all the terms. Do you need to have a meeting of the minds on all the terms in order to form a contract? No, you do not. Is it okay to say we have a deal? We will add some terms later. We'll work out some terms later on? You goddamn right. In fact, that's what the restatement says that we're being pointed to from this thing. It says, look, you can have a contract and agree to write it up later. Listen to what I just said. You can have a contract and agree to write it up later. That is characterization 1. What's characterization 2? Characterization 1 is we agreed and we're now writing it up. Characterization 2 is?
Still counteroffer.
Yeah, we're still negotiating. Do you see this? One party is stretching the negotiation period and the other party is trying to cut it off. Now, just, even though Riley's already given me the right answer, there it is, right? Even though Riley's already given me the right answer, which is it? On who's paying me, right? That is, it depends on the argument you are making as to whether or not you yank that lever to the negotiation lever. You're going to yank it out and say, no, we were still negotiating. Obviously, they were still negotiating. They were obviously still negotiating important parts of the contract. Or yank it to the other one. No, they had an offer, she accepted, sure there were some details to be worked out. The restatement actually says you can do that. And that's what all of the rest of the cases that we will look at are doing. It's going to be the same fact scenario 3 ways. There's going to be a whole bunch of law. One's a labor contract, 2 of them are for the sales of companies. Nobody cares. Every time I'll ask you, is this still negotiating? Or is this, they had a deal and they left some stuff to be written up? And every time the answer is, I don't know who's paying me, because I can win this either way. And I just need you to see the arguments that you make to make it. What's the best argument, Kristen, for saying they clearly didn't have a contract yet? And by the way, what case does this remind you of? We don't have a contract because they left certain important details not negotiated. Yeah, I did too. I'm pretty sure they said it. Who said it? Sun Printing. This is Sun Printing. Cardozo was wrong, but he was right, but he was wrong. And that's exactly this lever we're talking about, right? What was the deal in Sun Printing? Yeah, he's like, y'all didn't ever agree, even though you said you agreed, signed, sealed, and delivered, and in fact, we're already executing the contract. But he says you never really agreed because you left an important term open. What was the important term he left open? They left open. Yeah, the time within which the price was going to be negotiated. Well done. And so then we've got this, what I'll call a free option because the time was left open. That was the part of Cardozo that wasn't wrong. Here we see another mechanism that's doing the same thing. What I need you to see is not whether you win or lose here. I want you to see that you would take money and sleep well that night and expect to win, arguing that there was a contract here and that there wasn't a contract here. That's what I need you to see. Anybody clear on, anybody have questions about that? Otherwise, that's exactly what's going on here. Nate, yeah. Yeah, there is. It's in the agenda. There's a restatement. There's one restatement in particular that says it's fine to have an agreement and then leave details for later. It's also, though, and then it's incredibly helpful to lawyers, utterly non-helpful to humans, because then it says in the second sentence, and I can find it, and then it says in the second sentence, oh yeah, by the way, that doesn't tell you whether you're still in negotiations or not. Thanks for nothing. Right? It's not a rule of decision. It's a listing of the argumentative positions. Right? Very helpful to lawyers, not helpful to humans. That's 27? Thank you. Yeah, that's 27. Okay, cool. Liam.
How viable would an argument that said her intention when she said, I agree, was not actually to agree, but was just to move forward one step in negotiations? Because she clearly knew the writing.
Yep. What am I going to say about that? What am I going to say about the words I accept and what thou shall or shalt not do with the words I accept?
When discussing a contract, if you say the terms I accept, and the intent of that would be to accept the contract.
And what if my personal internal view was I said yes, but what I meant was?
It doesn't matter because of the objective intent.
Because of the objective theory of contract. Also expressed as the following maxim, thou shalt not beep with the form of a contract. Act like you got a contract? Congratulations, you have one. Contract cosplay is for suckers. Don't do it if you don't mean it. I saw one, it's a great case called Shattuck versus Klutzpah. It is not in this book, in which it was a contract for the sale of land. And what they did, the idea is you needed a writing and you needed to sign it at the end. And the person wrote it, attached it to an email, and signed it at the end. The court's like, you're done now. That was a contract. I know you said, I'm looking forward to closing next week. Guess what happened in the intervening week? Somebody got cold feet, wanted to back out. Tough. Thou shalt not beep with the form of a contract. You sent a signed agreement. It's a signed agreement. I'm not screwing with this. Yeah.
Towards the end of the discussion, it talks about how the contract was rescinded by mutual consent. So would it even matter, like, if you argued that wholeheartedly, if there was a contract, if you could prove that both sides disregarded the contract anyway?
Not disregarded, but rescinded. If both sides agreed to terminate the contract's gone. But then what do you do when, see, there's this other problem, right? People do this all the time. There is no contract. We haven't negotiated anything. And every time, y'all, what is the problem with Ms. Sandoval? Let's say that we agreed. There was no contract. There was no contract. What's the problem? She went to work. This is going to be our major issue. Part of our issue is people trying to call off contracts before they ever get off the ground. But the harder and more common problem is the parties don't have a contract in place and they start acting like they do. Anybody want to take a wild, uneducated, sorry, too late, you are now educated, guess on what a court's going to do with that? There's a contract now, based on? Yeah, based on your conduct. This will become a huge point later on. Courts like, I don't care if you both say there is no contract. In fact, it's true if you remember our exchange earlier about what's on the flip side of those form agreements, right? How they don't match up. Turns out they never match up. Turns out they absolutely never match up. It turns out there's a clause called a my way or the highway clause. It's going to say every deal in this has to be my way or there is no contract. And the other party says every part of this contract has to be my way or there is no contract. That's what it says in that boilerplate. And then the parties ship the widgets and pay for them. And you're just like, screw you. There's a contract based on your conduct. That's 22073. We will see that when we get to 2207. Okay? So that's the major problem, is that even if we saw it was rescinded, they still acted like there was one. And so then what do we do? Yeah.
In this case, isn't it that they're acting like there wasn't a contract to terminate her? Because she
Well, that there was not a contract to terminate her, meaning that there was a contract for her continued employment. Yep. Yeah. Yep. Cool. Okay. Anything further on this? Go for it.
Okay, maybe I'm just like misunderstanding the facts, but I'm confused how if there was a term in the contract that they would pay for 5 years of health insurance, how is that not a 5-year term?
Yeah, because they have to do it for up to 5 years.
Because any contract, like, yeah, someone could die and then it wouldn't be a 5-year term.
Well,
Or like a more than 1 year.
yeah, I mean, if it's a contract for personal services, no. But if it's like a contract to like get a franchise, then that would survive somebody's death. Look, I'm not, to be very, very clear, if you are looking for me to say this contract clearly must be in writing because of this term, I'm never going to say that is the fact of the world. I'll just say, yeah, really, really good argument. What do we do about it if opposing counsel says that? That's all you're getting from me. You're not saying that, I'm not saying that's wrong. I think it's brilliant, right? I'm not saying it's wrong. I'm just saying, what do I do about it? Because opposing counsel came up with something brilliant. And I still don't want to lose, right? I still want to earn my paycheck that day. Okay. Cool. Awesome, folks. Let's continue to move on in our last couple of minutes. We're going to go to this pair of cases. We won't get to MPRO today. We will get to Arnold Palmer. But the thing is, they're the same damn case, so listen up, because whoever gets MPRO next time is going to just get Arnold Palmer with a dose of Judge Easterbrook on the side. All right, what's going on in Arnold Palmer?
Well, Palmer and Fuqua are in this, I hope I'm saying that right, they're in this negotiation to combine businesses into a
Yes.
sort of super venture. They want to acquire some manufacturing, create this sort of joint enterprise together, and they create this memorandum of intent, and it lays out these very clear terms, including specific stock transfers, a $700,000 lump sum payment to Palmer in exchange for 25% of that company. They state in the memorandum that these are great terms, pending the ability for both sides to formally agree on it. This is what they want to do. They put out a rah-rah press release. We're in on this. We love it. Look how happy we are.
Which is the most important fact of the case.
Yeah. And then Fook was like, actually,
No.
not really.
Okay, let's get the...
So Palmer sues for breach.
Yeah, so let's get the black letter law out of the way here, because all of this is now at this point going to be argumentation and policy. There's almost no black letter law to talk about here, because the framing determines everything. First of all, what's the court do with this?
Well, at first, if I'm understanding correctly, it was pretty much determined that there was no actual contract. Right? So we get this determination that there's no contract.
By actual contract, what do you mean? Because there's this tension, right, between these two problems.
Right.
Was there agreement?
Yes.
Was there a final written up agreement? Was there a final written up document?
In fact, this case,
See, these are called memorandum of intent cases.
Right.
So the question is, what the hell do you do with a memorandum of intent? Now, there's two ways you could characterize it. Way one is, on this memorandum of intent, this is
what we want to do.
this is a contract. Okay.
Yeah.
What's the other expression of a memorandum of intent?
We're just talking about this right now.
Yeah, that this is negotiation. It's the same lever we've been looking at the whole time. Is this enough? Does it have? Let me ask, with Judge Cardozo, do they have to agree on everything in order for this to be a contract? No, they don't have to agree on everything. How did Judge Cardozo divide that? I get it that he was wrong, but his principle was probably a good one. What's a court going to look for to see whether or not this is a contract that's a done deal or an expression of intent in order to negotiate?
I guess their actions in proceeding forward.
Well, that's the main thing that they looked for, was that handshake on TV. That was not their finest moment, right?
Right, yeah.
What was Cardozo's argument about why he said that the deal wasn't there? Yep. Definiteness. He said that they've left some stuff unnegotiated, right? And so you can see that in these memorandum of intent cases where we say, we intend to do this, but we haven't hammered out all the details yet, you also have the risk that this could be determined just purely negotiations, not the deal. Among other things, there would be no reason to have a memorandum of intent if you didn't intend to have a writing later on. But that doesn't stop restatement 27. Remember, let's say we agree to this joint venture. We've hammered out enough terms so that Cardozo's not spinning in his grave. And then we get on TV and we fist bump. What's that called?
Consideration.
And a contract. So we need consideration, we need acceptance, we need offer. That fist bump is working all this, and we need some kind of mutuality or meeting of the minds, that phantom fourth category that's not really there, but it is, Cardozo says, where the parties haven't really agreed on enough to move it out of negotiation into actual contracting, although Cardozo was nuts because they clearly did have the deal, right? And then he's like, yeah, but you left something undone. And instead of filling it in with reasonableness, he's just like, you never had a contract in the first place. It's nonsense, but the instinct is going to be the same for every one of these cases. Are we still negotiating in that memorandum of intent, or is it the real thing? Okay, now, what does the court say then about that question of, does everybody see the two characterizations? Yeah? Okay, what does the court say then as a matter of law? The holding of the case is pretty fuzzy. What's the court say about whether or not this is just negotiations, or the memorandum of intent actually has enough nailed down that that fist bump on TV means offer, acceptance, consideration, and enough definiteness, we'll say. Meeting of the minds is, well, the way I was taught it, but Raffles versus Wickelhaus gives me, like indigestion. So we'll come up with somehow worked out enough for the court to say, yeah, this looks like the real deal.
It really seems like they just kind of punted back to a jury.
They absolutely punt it back to the jury. I need you to understand what the move there was, though, and why that's so important. Who won getting it punted? I know what the court does later on, but who won getting it punted back to the jury?
Palmer.
Yeah, why?
Because Fuqua had walked away. Palmer wanted this deal to happen, and Fuqua had gotten a summary judgment. Right. There was no deal. So by going back to trial, they can at least now get a factual determination from a jury.
Right. But I need you to see that Palmer had do you see that Palmer has the harder case to make here? Right? They're rough. Because the basic principle that courts will follow, this is not a principle of law, it's just comprehensible. You have a contract when you have a signed final agreement. Well, as Liam points out, that's always very different from, did we have a contract? Do we have a signed final agreement? That's statute of frauds question. That's not a do we have a contract question. And worse than that, by the way, let's say that can you Fuqua this if you do have an agreement, a signed, sealed agreement? Can you still say, yeah, but we left so much undetermined that we actually don't have a contract? Yeah, David. How? Yeah, you left major things open. Go ahead.
There's a misunderstanding of intent between the two parties as to what the contract is.
The parties never actually, it's the same argument twice, right? The parties never reached agreement. That's what the court's worried about. Did the parties sufficiently reach agreement? Now, that is not in the black letter law of offer, acceptance, consideration. It's kind of a mutated thought experiment descendant of the meeting of the minds, or what's called mutuality of obligation component. But I need you to see it here because it's absolutely emblematic of the problem that we're dealing with here, which is we have these extended series of negotiations, multiple pieces of paper. Among other things, let's try this. The parties, I accept, they agree. They not only sign the deal, but then they stand there on public television and they shake on it, and then 2 weeks later somebody's like, hey, you know what? Although we left this very important factor undetermined, Can you see that even having the signed sealed agreement doesn't stop this problem of indefiniteness in negotiation? And then as a lawyer, what do? Well, if you want to undo the contract, find some major thing that the parties haven't talked about and claim that that meant that the parties never reached agreement. Should it work? No. Does it work every once in a while? Ask Arnold Palmer. It worked in that case. The reason I'm setting that up is one, because I got to let you go. And two, because Empro, Judge Easterbrook I disagree with on a whole lot of things, but you're going to notice Judge Easterbrook goes through this with a flamethrower. He's just like, look, y'all, if you say we do not have a deal, we're going to write it up, and then you don't do that, and I know this is shocking, you don't have a contract. Now, Judge Easterbrook's a formalist, among other things, so he loves saying that the existence of the contract is synonymous with its written expression. He's wrong, but it's the most convincing thing you can say to a court. He's wrong. You can have a contract without writing it up. You can have a contract and write it up later. But so help me, if you don't write it up and you don't sign it, you're about to have Empro problems. All right, thanks folks. We'll pick this up next time.